So welcome everyone. First of all, I'd like to thank Latham & Watkins for hosting us today for our U-Visa Pro Bono training. My name is Tricia Tiafilo Olave, and I'm the legal supervisor of the VAWA and U-Visa Pro Bono project at the National Immigrant Justice Center. I'm here with my colleagues Sylvia Wolak and Christina Rodriguez, both part of our VAWA and U-Visa Pro Bono project. And Sylvia and I are going to be talking to you today about the U-Visa, what it entails, and how to prepare a U-Visa case. So without further ado, we'll go ahead and get started. So first of all, I want to just explain a little bit about the National Immigrant Justice Center. We are a nonprofit agency located here in Chicago. We do have offices outside of Chicago, but primarily you'll be dealing with Sylvia and I, who are based here. We mostly have clients from this area, but occasionally we have clients from other parts of the country too. And we do a unique combination of direct legal services with impact litigation, and we have a big outreach program. We do outreach in the community. We reach out to clients, get them into our office, do intake, and then put them on a pro bono list to refer out to you. We serve over 10,000 immigrants annually, and we're able to do that with the assistance of our large pro bono network of over 1,500 pro bono attorneys. So thank you to all of you, because without your assistance, we wouldn't be able to help as many clients. So today we're going to talk briefly about the various pro bono projects available at NIJC. We're going to talk specifically about working with survivors of domestic violence, because a lot of U-Visa applicants are survivors of domestic violence. So we want to give you tips so that you're comfortable doing that. And then we're going to go into the specifics of preparing a U-Visa case. And we're also going to provide you with resources. So here's a list of the various pro bono projects that are available at NIJC. Our Asylum Project assists clients who are fleeing persecution in their home country. The Detention Project represents clients who are detained in immigration facilities. Our litigation team does federal litigation. We have a few different clinics for DACA, which is Deferred Action for Childhood Arrivals, naturalization, and then post-asylee benefits. We have a Children's Project, which represents children who are predominantly applying for special immigrant juvenile status, and our VAWA and U-Visa Pro Bono Project, which assists clients who have been in domestic violence relationships or victims of serious crimes. So the way our pro bono projects work, as I mentioned, the client will meet with us first at NIJC, and we will do a thorough assessment of their case to determine what forms of relief they're eligible for. Once we determine that they're eligible, for example, for a U-Visa, we'll meet with them until they're ready to go forward. So once they have all of their documentation ready, we will sign a pro bono retainer with them, and then their case goes on the list. So at the stage that you actually get the case, the client has already been fully vetted, and we know that this client is eligible for this form of relief. So you don't have to worry about that. We've already made that determination. However, after this training, you're going to understand more about the legalities of a U-Visa. And so if you have any questions, you can definitely reach out to Sylvia and I. Once the case is accepted, then we put together a case referral packet. So when you contact us saying, I'm ready to take on a case, we'll send you the conflicts for that case to make sure that there's no conflicts between you and your firm and the client. And then if you take on the case, we'll send you that case referral packet to allow you a chance to sort of review the case before you reach out to the client. Throughout the life of the case, we remain of counsel. So we will have a file at our office that we will maintain and keep in touch with you throughout the case. If there's any requests for evidence or notices from immigration, if you receive any documentation, you should let us know so that we can make sure to advise you thoroughly. Okay, we provide technical support. So if you have any questions, you can reach out to Sylvia and I. And then finally, we provide a review of the filings before you file them to make sure that you're not missing anything. So here's sort of a list of the various responsibilities of each player in this process. So NIJC does the outreach, we screen the cases, we support the pro bono attorneys, we provide trainings, and then we provide technical support and case review. We also provide malpractice insurance and remain of counsel. You as a pro bono attorney will attend a training, so thank you, step 1 is done, and then conduct a conflicts check. You'll schedule a client meeting, and then prepare the case. And generally this can take anywhere from 8 to 12 weeks. We recommend that you schedule that initial client meeting within the first couple of weeks, or at least reach out to the client so that they know who you are. And keep us informed throughout the life of the case. If there's a need for translators, that would be on you to find an interpreter for your client meeting. Sometimes the firm has interpreters that you can utilize. Sometimes the client knows someone, but we generally recommend not using like their children, for example, because if they're going to be talking about very private details about domestic violence or things like that, it's usually not best to have the child be interpreting. And then, of course, the client has responsibilities too. We ask that they remain truthful and that they communicate with you. On occasion, we've had to close cases because the client loses touch with you or us. We try not to do that, so we ask that you maintain communication with the client. But if that communication were to break down, you can reach out to us and we'll figure out what's the best option. So any questions before I turn it over to Sylvia? Okay, great. Thank you all for being here.
Thank you very much, Tricia. Before I move on to talking about working with survivors of domestic violence, I also want to draw your attention to the materials table. Please make sure you sign in for your CLE credit, and then I have the CLE certificate up here at the desk. We ask that you fill out a training review sheet, let us know how we did today, and then I'll hand you the CLE certificate. So just to draw your attention to that. So as Tricia mentioned, many of our U-Visa clients are survivors of domestic violence. Just by a show of hands, how many of you have worked with individuals who have been through significant or severe trauma? Wow. Okay. So this may be redundant to some extent, but also hopefully it provides some sort of framework for you about what it looks like to work with a survivor of domestic violence in the U-Visa context. So it seems like we have a group here that's fairly experienced with that, and that's really great. So I'll try and focus in on what that really means for the U-Visa. All of our clients are at 200% of the federal poverty guidelines, or lower, or they make less than that. So they are already facing some significant barriers when it comes to accessing legal counsel and certainly economic hardship. There are some other cultural barriers that we typically see in the office that the immigrant client may be facing, language limitations. And so specifically in the U-Visa context, by the time the client gets to us for a legal screening, they may have been through a number of hurdles and a number of hoops already. If English is not their primary language, they may have had trouble speaking to police or accessing police protection from their abuser. They may have had difficulty certainly even getting to the point of accessing legal counsel. They may be facing extreme isolation, either perpetrated by their abuser, or they may be isolated within their community. There may be some cultural ideas of abuse or family shame and honor. So sometimes we'll hear things like, my community encouraged me to handle the situation within my home, within our religious circle, and so I didn't seek help. I didn't call the police for a long time. So those are the kinds of things that we often hear and see, and it's something to be aware of. That by the time the client gets to you, they've been screened multiple times, and they may have been through many, many hurdles already. So what are the kinds of things that are helpful to think about when working specifically with a survivor of domestic violence? I think the power and control wheel is a helpful framework for that, and especially for thinking about the tactics abusers use to exert control. So there are some common things that we may typically think of. For example, physical abuse, sexual abuse, threats, intimidation, certainly those overt things, but there are other things that you may not think of immediately, and the client may not think of immediately. For example, economic abuse. Does the individual have access to money or bank accounts? Can they get on a bus? Or do they not have the money for a bus pass? Things like that. Are they really trapped in that relationship because whatever income they make, that money is going directly to the abuser, and the abuser controls the income, and they control, therefore, mobility, they control access to things like legal counsel and really getting help. Emotional abuse is something that we commonly see. And then certainly something that I want to bring to your attention is citizenship or residency privilege. So for a U visa, you don't have to be the victim of violence perpetrated by a citizen or a legal permanent resident, but certainly we see people who are in relationships with citizens or permanent residents, and those abusers are able to exert control over that person by saying, if you call the police or if you say anything, I'm a citizen, I'm a legal permanent resident, they won't believe you. I am going to tell them that you're not legal and you're going to get deported. So those kinds of threats are very, very common, and it leads the survivor of domestic violence to not seek help, or maybe they've been in this cycle for many, many years. So those are all things that are helpful and important to understand, especially when drafting something like your affidavit, to think more broadly about the types of power and control that the abuser may be using and subjecting the victim to. So those are just some of the examples that I've already mentioned here. And then the other thing to think about, or that we commonly see when working with survivors of domestic violence, is that there's a cycle of abuse that often happens. Certainly it's not in every case that there's been this continuous victimization over many years, but it is something that we see fairly commonly. And so I think it's helpful to frame it in your mind as well. Usually what we'll see is, we'll ask the individual, and we certainly recommend that you do at the start of writing an affidavit, how was your relationship at the beginning? And clients often say things like, in the beginning things were very good. I was made a lot of promises. I thought I had finally found some stability in my life. Maybe there was a previous issue in home country where the individual was abused, and they thought that they had met someone or found someone that was going to provide them with stability, love. So there's this honeymoon phase where lots of promises are made, and that usually moves into the tension building phase. So maybe not overt violence, but some of those other things that I mentioned, like control, economic control, isolating the individual, saying you can't go see your friends or family because I don't trust them, or I think you're cheating on me, so you're only allowed to talk to me. So these sort of tactics that really sort of imprison the individual in that relationship, but maybe things that we wouldn't consider overt violence. And then oftentimes all of these lead to an explosion. And so that would be something that can often lead to the qualifying crime of domestic violence, right? Maybe there's physical abuse, the individual has to call the police, or someone else calls the police because they witnessed the abuse. And then oftentimes, for individuals who have been in this type of relationship for many years, this cycles right back into the honeymoon phase. The abuser makes promises, says this will never happen again, re-enters that courtship phase. The reason this is important to think about, especially when you're working with your client, is because even though the U visa, the qualifying crime, may be one particular instance of an explosion, it's really helpful to explain and paint the totality of the circumstances in the relationship. And so it's typically not just one time that the abuser was abusive. It's typically this cycle over and over again. Maybe there's a lot of tension building after a certain period in the relationship. And so even though the client may focus on this one instance of explosion, it's important to really tell their entire story and ask them questions, right? Was this the only time that you had to call the police, or were there other moments where things happened but you maybe didn't call the police? So this is particularly helpful when working on something like the affidavit. And we do have this cycle of abuse explanation, as well as the other chart in our manual for the U visa, and you can even work with your client using that as a visual aid, especially if the client is having trouble sharing or thinking back to these moments. Are there any questions before we move into talking about the U visa? Okay. Great, thank you very much. So I'll turn it back over to Tricia.
Okay. So you can see we have a lot to talk about with U visas. Have any of you done U visa cases before? Oh, wow. So a lot of you are already familiar. So hopefully this will be a refresher. If you have questions, please ask. Most of you then probably already know that the U visa was created back in 2000 as part of the Victims of Trafficking and Violence Prevention Act. So it was developed as this sort of dual intent visa. We'll help you if you help us. So the clients have to assist law enforcement in the investigation or prosecution of the crime. And then in turn, the idea is that they can get this visa to allow them to stay here to assist with the investigation or prosecution of the crime. Sometimes clients who don't have immigration status are afraid. They're reluctant for some of the reasons that Sylvia mentioned. A lack of legal status, right, can make it scary to come forward to law enforcement. So this was created to strengthen that relationship between law enforcement and the undocumented community. There are various benefits to applying for a U visa. You get a non-immigrant visa, which is valid for 4 years if your U visa application is approved. Okay, so it's a non-immigrant visa, which means that it's a temporary visa. So it's valid for 4 years, but after 3 years in U visa status, you can apply for a green card. So it does have a path towards citizenship, right? So you get this non-immigrant visa, you can eventually apply for your green card, which is the same as legal permanent residency. And then typically, after having a green card for about 5 years, most people are eligible for citizenship. So long term, this could be a path to citizenship. Another benefit is that you can include various derivative family members. Okay, so the relationship must exist at the time that they file the U visa application. But if you are an adult, you can include your spouse and unmarried children who are under 21. If you, as a victim, are applying and you're under 21, then you can include even your parents and siblings. So we'll get into more details about that later. The biggest limitation with the U visa is that there's an annual cap of only 10,000 U visas that are granted per year. And although that might sound like a lot, the cap has been reached for the past few years, which means that there's now a backlog. Okay, so when the U visa first came out in 2000, we didn't have any regulations. They finally came out with the regulations around 2008. So people have been applying for U visas since then. In the first few years, there were not many granted. But then after maybe about 5 years or so, we started to reach the cap. And so now USCIS is currently adjudicating cases that were filed in 2015. So that means it's going to be about 4 years or more until they get to your client's case. However, they have created this workaround where they've created a wait list, and Sylvia's going to talk more about that later. But so we wouldn't want somebody to be discouraged from applying simply due to this cap and the wait list. If they're eligible, oftentimes the U visa is the only form of relief that some people are eligible for, so we would still encourage them to apply because it's better than nothing, right? Questions? Okay. So yes, of course. So that's a really good question for recording purposes. Has the administration tried to deport anybody that's applying for a U visa, right? So we haven't seen them actively try to deport people who have U visa applications pending typically. The U visa application, if it's pending, is not necessarily a protection from deportation. Once you're placed on the wait list, you are granted deferred action, which deferred action, although it's not a legal status, it is sort of protection from deportation. So the goal is to get somebody on that wait list. Now, although that can take quite a while, we have seen immigration, like ICE, for example, who are the enforcement agents, be sympathetic to people that have U visa applications pending so far. So will that stay? I don't know. Generally, for example, what happens is if a client is reporting to ICE because ICE knows that they're here without status, they have to report in, and we generally have a stay of removal prepared in the instance that it's required. I don't think we've had any clients in our office who are in that posture who have been deported, though. Now, just last year, there was a new NTA memo, that stands for Notice to Appear, that was released by the administration, which basically says that if you apply for any form of relief and it's denied, you can immediately be issued a Notice to Appear and placed in removal proceedings. So to give you some background, historically, applying for a U visa application did not really include any risk. Okay, all of these applications go to the Vermont Service Center. The Vermont Service Center is trained in domestic violence and was generally known as the more compassionate of the service centers for USCIS, and so there was minimal risk in applying for a U visa application. Since this NTA memo has come out, we are more wary that it is possible, of course, that they could refer somebody to removal proceedings. They actually could have done that at any point, but they just weren't doing it. And so people have asked, have we seen that happening? Well, unfortunately, we haven't seen that happening yet. We honestly don't see many denials in our office because we put together really good cases and try not to file unless we think that somebody has an approvable case. Now, I don't know if that will continue or not. When we're screening for the cases, though, we're very clear with the clients about the potential risks, and so that they understand it has to be their decision, right? Most clients, though, would rather try to apply if they are eligible for this form of relief than remain here without anything, right? So it's all about weighing those risks and benefits. But yeah, with the new administration, there seems to be a harder line, but we haven't seen it enforced yet. So I mentioned briefly derivatives. Again, if the victim, the principal applicant, is under 21 at the time of filing, they can include their parents, siblings who are under 18, any unmarried children who are under 21, and a spouse. Okay, so for example, if we're talking about a 19-year-old who happens to be married and has a child of her own, and her parents live here, and all of those people are undocumented, if she's the victim of a sexual assault or a felonious assault or something like that, she can be eligible for a U visa and include all of those people as derivative applicants. You cannot ever include the perpetrator as a derivative applicant. Okay, so if she was a victim of a crime by her spouse, he could not be a derivative also. But if it was from an unknown offender, then he could. If the principal applicant is over 21 at the time of filing, then you can include your spouse and unmarried children. Now, the standard of proof for U visa cases is any credible evidence. And as Sylvia mentioned, working with victims of domestic violence is sometimes challenging because if they're fleeing domestic violence, maybe they fled their home without thinking to grab all the documentation they're going to need for their U visa case, right? That's probably not the first thing on their mind. So we work with the clients together as much as they can, but we also oftentimes need to gently remind USCIS that the standard is any credible evidence. So if the client has some evidence, but maybe not everything that USCIS might want, we would push back and insist that, it's still approvable based on what they do have. And also for these cases, oftentimes the client's affidavit is the single most important piece of evidence to prove the various elements. So you cannot apply for a U visa without the certification from law enforcement, which we'll get to in a moment. But everything else, you want to gather documentation to prove the various elements, but sometimes the affidavit is going to be the strongest proof. So briefly, to talk about who is a victim, right? So there's various forms of victims that can qualify for U visas. The most likely is a direct victim. So that would be your general idea of who is a victim. It's the person who is directly and proximately harmed by the crime. There is also this definition of a bystander that could apply as a direct victim, but a bystander would generally be somebody who witnesses the crime and suffers unusually as a direct result of that crime. So if you think about a woman who miscarries as a result of witnessing a violent crime, okay? This is pretty unusual. We don't see this very often, but just so that you know it's a possibility. We do also see a lot of indirect victims of crime. So that would be if the actual victim is deceased due to murder or manslaughter or incompetent or incapacitated, then the direct victim can include the spouse children under 21, parents and siblings. Now, we have occasionally seen this in murder cases, but where we see it more commonly is parents of children who were victims of sexual assault. Okay, so the child could be considered incompetent or incapacitated due to their age, and then the parent can qualify as an indirect victim. Okay, so yes.
In those situations, is the child also?
So yes, if necessary. If the child does not have immigration status, the child could apply as a direct victim and include the parents as derivatives on their application, or the parents could apply as indirect victims and include the child as a derivative on their application. Strategically, we will determine that usually based on the child's ability to have cooperated with law enforcement and fulfill the other elements of the crime, right? If the child is applying as a direct victim, they would have to prove all of those things, where oftentimes it's the parent that's actually fulfilled those requirements. If the child, however, is a U.S. citizen, doesn't need any immigration assistance, then the child can't apply, so then you're going to go with the parent applying as an indirect victim. There is a definition of a next friend. That would be a person who appears in any lawsuits on behalf of the immigrant who is incapacitated or incompetent or under the age of 16 and has suffered substantial harm as a result of the crime. So the last thing we would need to consider then for these cases is, what is the age of competence? Well, there's not a clear answer. It varies in immigration, state, and federal laws. For U visa purposes, we generally look to victims who are under 16, but we could potentially make an argument for somebody that's 16 or 17 years old. But it's best practice to really show that both the direct victim and the indirect victim have suffered substantial harm. Okay, so if you're talking about that case where the child was a victim of sexual assault, but the parent is applying as an indirect victim, you're going to want to show that the parent also has suffered substantial harm. And usually it's more of, mentally and emotionally. If your child's been a victim of sexual assault, how did you suffer? Not that they necessarily suffered physically. Okay, so once we figure out who the victim is, then what else do they have to prove? Well, they have to prove that they have suffered substantial mental or physical abuse as a result of the qualifying criminal activity. Okay, they have to prove that they possess information about the crime, that the criminal activity occurred in the United States or violated U.S. law, and that they have been helpful, are being helpful, or are likely to be helpful in the federal, state, or local prosecution or investigation of the crime. Okay, now it's important to note in number 4 there that it's either the investigation or the prosecution. So if they assisted in the investigation by reporting the crime and cooperating with the police, that's sufficient, even if the crime was never prosecuted. Maybe the perpetrator fled or the state's attorney's office decided not to prosecute for whatever reason. Okay. On the other hand, if maybe somebody else called the police and they were, in a coma because of the criminal activity, and so they weren't necessarily helpful in that investigation, but then they testified in the prosecution, then they could get a certification from the state's attorney's office in order to apply. So how do we prove these various elements? Well, substantial physical or mental abuse is actually defined as injury or harm to the victim's physical person, or harm or impairment of the emotional or psychological soundness of the victim. And that's from the Code of Federal Regulations. And as Sylvia mentioned, it doesn't have to be any single factor. It can be a totality of the circumstances, okay? So depending on the crime and the case at hand, if it's a felonious assault case and your client was a victim of a gunshot wound, then it's probably going to be one incident that you're looking at. But if it's a domestic violence case and you're looking at years of abuse where they didn't call the police until one incident that doesn't really seem as severe as the others, you can explain that all of those years of abuse were part of the crime of domestic violence. So USCIS is going to consider various factors. They'll look at the nature of the injury inflicted, the severity of the perpetrator's conduct, the severity of the harm suffered, the duration of infliction of the harm, right? So if it's been years and years and years of harm, and then the extent to which there is permanent or serious harm to the victim. Possession of information, that's pretty self-explanatory, but generally the client must have knowledge of the qualifying crime. So if they were knocked out at the crime scene and they don't remember everything, that's okay. They can still go forward, but they're going to want to cooperate as best they can. If the victim is less than 16 years old or incapacitated or incompetent, then it can be a parent, guardian, or next friend who possesses that information and assists. You want to always look at the age of the victim on the date of the qualifying crime to determine if they can use an exception. Now here's a list of the various qualifying criminal activities that are eligible for a U visa. So the way it's written, it involves one or more of the following or any similar activity. So as you know, the state laws are not always the same from state to state, and federal laws differ too. So what's considered extortion in one state might not be in another state. And so, what you want to do is look at the laws in the jurisdiction where the crime took place, see if it fits under any of these or any similar activity. And it can also include attempts, conspiracy, or solicitation to commit any of the above crimes. So the ones that we see most frequently are domestic violence, felonious assault, sexual assault. Occasionally, we'll see trafficking or kidnapping. Those are the most common ones, though. And then, as I mentioned, the cooperation with law enforcement is essential. So there is a form, the I918 Supplement B, which is mentioned there at the bottom. Without that form signed by a law enforcement officer or a judge or prosecutor, the client cannot apply for a U visa. Okay, if you submit a U visa application without the certification, it's going to be denied. So you have to include the certification. The certification form is signed by either the law enforcement officer or the state's attorney's office or the judge, and it's valid for 6 months. So from the date that the client gets that certification signed, they have 6 months to submit their U visa application. So usually when the client comes into us with the certification signed, we'll make sure they have everything else ready and try to get the case on our pro bono list as soon as possible. Sometimes clients come to us right before the certification expires, and so then we'll work with them to determine, can they get a new certification signed or not. Some law enforcement agencies are more amenable to signing follow-up certifications. The certification in and of itself is not sufficient proof for any elements of the U visa, but it does obviously go towards proving cooperation. The form basically asks law enforcement to certify that someone has been a victim of a crime. And so you also then need to prove that they've been helpful, that they're assisting the law enforcement in either the investigation or the prosecution. So if the client went in to testify, you would include proof of that, or if they simply reported it to the police and then that was all that they were able to do, you include that information in the client's affidavit. It does require an ongoing responsibility on the part of the victim to continue to be helpful. And so we let the clients know that so that they continue to cooperate. Occasionally, it will come to the situation where a client doesn't feel like they're safe or that it's unreasonable for them to continue to cooperate. So there is actually an exception in the Code of Federal Regulations that clients are excluded from cooperating after initiating the cooperation if continuing to assist would be unreasonable, okay? And so, for example, we've made that argument in a few rare cases where a client felt that their life was at risk for retaliation if they continued to cooperate. So I wouldn't recommend that on the get-go if you don't have to, but just know that that is an option if necessary. As I mentioned, the certification form, you have to include the original. So what we usually recommend is on your first meeting with the client, go ahead and gather that original certification from them to make sure that you have it. Because otherwise what happens is you're putting together your packet right before the certification expires. You realize you have a copy when you copied all the client documents and you don't have the original. And the clients, they do their best, but especially if English is not their native language, all of the papers look the same to them. So they might lose that paperwork. We give it to them in a manila folder and write, original and big letters so that they give it to you. But I recommend you get it as soon as possible. That certification needs to be completed by the head of the certifying agency or somebody who's designated by the head of the agency. And we make sure that that person is authorized to sign before we send the case off to you. And as I mentioned, it's good for 6 months, and it's not conclusive evidence of any of the eligibility requirements. Questions so far? Yeah. Sure. So the question was, have we seen any cases where the initial complaint was baseless and then the prosecution didn't go forward, right? So I can't think of a case specifically like that. What I did see was a case where the father came in and thought that his son had been a victim of kidnapping, and that it seems to be a qualifying crime. But then when we saw the police report, so we FOIA'd the police department to get more evidence to make sure that everything was what he thought it was. When we saw the police report, it turned out that the son had actually been a part of this prank to get money, right? So it wasn't really a kidnapping. It was really that the kid was in on it. I don't know why, but anyway, so all of that to say, we generally try to do as much research up front before filing a case to make sure that something like that's not going to happen. On the other hand, if a client truly was a victim and there was no prosecution, but they've assisted, because maybe the perpetrator fled to the home country or many reasons, right, that a prosecution might not go forward. If we feel that we can still prove all of the elements, we would encourage the person to apply, right? So it might come down to what it seems to be, the client's word versus no evidence, right? But if a client is eligible for this form of relief, we think that they should be able to apply. So I think, if you get a case though, and you're talking to the client and things just don't add up, definitely raise that with us. We would try to catch those things ahead of time. And I like to give the benefit of the doubt to our clients, but I've also been doing this a long time and I've seen a lot of things. And so sometimes, weird things happen. I know that there is some pushback in Congress that people say, oh, the U visa is filled with fraud. I'm sure that there have been some cases of fraud. In fact, there have been some indictments of attorneys that have filed fraudulent cases, right? I think that happened in Indiana like last year or the year before. And so then, USCIS goes through all the people that have filed applications or through that attorney. And they're probably going to be extra suspicious if that attorney helped you file a case. We try to do all the vetting up front to make sure that any cases that we're filing seem legit, so we would not want to file anything that's fraudulent, and we definitely would not want to pass anything on to any of you that we had any suspicions of. Question?
So obviously there's
Mm-hmm. Sure. Okay, good question. The question is, do you have any status while your application is pending? So, if they're currently adjudicating cases from 2015 and it's going to take 4 more years till they get to your case, what happens while you're waiting? Unfortunately, you don't have any status. Once your case has gone through an initial review, they can put it on the wait list and grant you deferred action. And so at that point, you can get deferred action, which, although it's not a status, it is some protection. For a period, it was only taking them about 6 months to get you on a wait list. Unfortunately, that is now backlogged too. We're pushing back with immigration to try to get them to speed up their processing times, but really it's out of our control, right? We can push and we can do congressional inquiries and ombudsman's inquiries and all of that stuff, but ultimately there's no status until the visa is actually approved. However, with that being said, your question about like a driver's license and things like that, depending on where the client lives, they might be eligible for, like here in Illinois, we have the temporary visitor's driver's license. So here in Illinois, undocumented immigrants can obtain a driver's license, can open bank accounts and things like that. So and should file taxes. And so we provide referrals to all of those things. So if your client is like, oh, I just don't know how to get my driver's license or where to go to file my taxes, contact us and we'll provide those referrals for you. Okay. More questions? Yeah.
What happens if during the pendency of visa the underlying crime is resolved?
Sure. So that happens. And I should also say, there's no statute of limitations for how long before you can apply for a U visa. So your question is, what if the criminal case is resolved during the pendency of the U visa? That is separate from the U visa case, and it doesn't affect your eligibility. Similarly, if the crime occurred 20 years ago and you were a victim of domestic violence or whatever, and you just now learned about the U visa or it didn't exist at the time of the crime, you can still apply for a U visa now, as long as you can prove these various elements of eligibility. So it's going to depend, right? The Chicago Police Department is very willing to sign U visa certifications as long as the person is listed as a victim on the police report. So if there was a police report from 20 years ago indicating that your client was a victim of domestic violence, they can go into the CPD headquarters and get a certification signed. And then they'll still have to prove those other elements, but it doesn't matter what the outcome of the crime was. On the other hand, if it's an ongoing criminal investigation and your client has a case and maybe it's being prosecuted at the time, I would probably encourage them to get a certification from the law enforcement agency first, like CPD if possible, because they have already assisted in the CPD component, right? They reported the crime and they assisted the officers. With the criminal case and the prosecution, you don't want the criminal defendant's attorney to ask to see U visa papers or to claim that the client is only applying for, only claiming that this was a crime in order to get a U visa, right? You don't want their attorney to have some sort of argument against your client because they suspect that that's why they're reporting this crime. So strategically, and that's all stuff that we would see on the front end of it anyway, but strategically, we might choose to get a certification from the law enforcement agency rather than the prosecution because of that. Generally, the Cook County State's Attorney's Office is also really great about signing certifications, and it hasn't been a problem, but we just don't want to put our clients in any unnecessary jeopardy. Yes?
So what happens when, especially with cases I think where either abused or spouse back, and the police report was never filed, right? But there relief, U visa seems strongest, but the incident happened a while back, and no police report was filed. There was sort of no investigation. What sort of happens in that scenario is that to show that something happened.
Sure. So the question is, what if that crime happened years ago, but the police were never called, there was no police report issued? Is there still a possibility of applying for a U visa? So generally, if there's been no report or assistance with law enforcement, there's no U visa case. However, you can try to file a late police report. I think that they're probably more likely to take a late police report in some kinds of cases versus others, right? Is there some other benefits to doing that? Is this person still harming other people, right? Like if it was a child sexual assault case and the perpetrator is still in the community and doing this to other people or something like that, maybe they'd be more willing to take the report. But I think it could be challenging to go in and file a police report based on domestic violence for something that occurred 20 years ago, and then also turn around and say, okay, now sign my certification request. Although they might do it, they might sign it, I think USCIS is going to be especially looking very closely at that case to determine, did this really happen? Are you just making it up? That's not a case that we wouldn't encourage somebody to go report a domestic violence case 20 years later, right? There would have to be some sort of, probably a new incident that we would recommend that they report. You know, and sometimes clients are still with the abuser. There's no requirement that they no longer be with the abuser in order to apply for a U visa. So as much as we don't want another incident to occur, if they've never reported anything to the police in the past, they're not eligible at the moment, right? And so we would let them know, obviously, that their safety is the most important thing. But if they choose to stay in that relationship and something else were to happen, if they report it to the police, they could be eligible for a U visa. And that's sort of how we explain it, right? We can explain the elements of a U visa and how they can be eligible, and then they can make the determination of if they'd want to report it in the future or not. Because a lot of clients have various reasons for not reporting. Other questions? These are all very good questions. So the last thing I want to talk about is admissibility. So if you've done immigration cases in the past, you all have probably heard of inadmissibility, which in immigration law can define a number of things that make somebody ineligible for a visa or the green card. So a U visa applicant, all principal and derivative applicants, must prove that they are admissible to the United States or seek a waiver of inadmissibility. The great thing about the U visa waiver is that it can waive almost everything. So there are many clients who are not eligible for any other forms of relief based on certain inadmissibility grounds, right? Like if they've made a false claim to U.S. citizenship, or if they have prior deportation orders, they might not be eligible for any other forms of relief, but those things can be waived with the U visa waiver. The only things that cannot be waived are INA section 212A3E, which is participation in Nazi persecution, genocide, acts of torture, or extrajudicial killing. Fortunately, I haven't seen any of those cases, so generally we encourage people to go forward with the U visa and their inadmissibility waivers. Now, I will say, though, that they have gotten tougher recently, and the cases that are most likely to be scrutinized would be clients with severe criminal histories, drug convictions, drug trafficking convictions, things like that, okay? There's a list of the various inadmissibility grounds that could make somebody inadmissible. So you can see a lot of things. Entry without inspection, that's very common amongst our clients. Previous unlawful presence or removal from the United States. Fraud, so if somebody entered with a fake visa or somebody else's green card, that would make them inadmissible. And smuggling, which can include bringing your own children to the United States. So all of those things can make somebody inadmissible, but fortunately there is a waiver available. In order to get a waiver for a U visa case, you have to prove that it is in the national or public interest for the waiver to be granted. That's very vague. It's generally, we're trying to show immigration that this is a good person and why it is in the national or public interest for them to stay here. So we ask clients to gain documents proving that they've been involved in the community or that they're involved in their children's lives, they're paying taxes, working, even if they're working undocumented, but that they're contributing to society in a positive way, we'll include that proof. The U visa application itself does not have a fee. Immigration does not charge for the U visa application, but for the waiver of inadmissibility, there's a $930 fee. Okay, so as Sylvia mentioned, our clients are pretty low income. For most of them, that's impossible. And so they can request a fee waiver in order to not have to pay that fee. And Sylvia's going to go over how to request that fee waiver in a little bit. But just know that that doesn't prohibit somebody from applying for the U visa waiver. And then the waiver is discretionary. So USCIS will consider various things. They're going to look at evidence of rehabilitation. So if the reason that your client is inadmissible is because of criminal convictions, right, then they want to see that the client has rehabilitated. Reasons for wishing to remain here in the United States. Do they have family here? Are their children born here? And any mitigating factors that are in the client's favor. So weighing those positives over the negative grounds of inadmissibility. Oftentimes, the client's affidavit is where you can touch on all of these issues. So the client in their affidavit should explain all of the specific circumstances surrounding their inadmissibility grounds and why it's in the national public interest to grant the waiver. And then, of course, you can look at things such as loss of access to the U.S. criminal justice system. So if your client, for example, has been a victim of domestic violence and the perpetrator follows them to their home country, but in the home country they wouldn't have access to protection from domestic violence, then that would be a reason for them to want to stay here and why it's in the national public interest for the client to stay. And then any physical, medical, mental health, or social services that the client requires but are not available back in their home country. So all of these things can be considered. Finally, it's important to note that these applications fall under the confidentiality provisions of the Illegal Immigration Reform and Immigrant Responsibility Act, or IRA, and the Department of Homeland Security and Department of Justice are prohibited from sharing any information about these cases to third parties. So if your client is concerned about applying for a U visa because they're afraid that their abuser is going to find out, you can tell them that they're not going to find out unless they tell them, right? So we encourage our clients not to tell the abuser that they're applying for a U visa, and to find some relief in knowing that it's illegal for the government to share that information. It's also illegal for DHS, the Department of Homeland Security, to make a decision about the client's case based solely on information provided by the abuser. So if the abuser contacts immigration saying she's making it all up just to get a U visa, DHS will have to give the client an opportunity to respond, okay? So we added this slide because of all of the ICE enforcement that has taken place over the past couple of years. And it goes a little bit to the questions that you all have had about, you know, clients, do they have status while their U visa is pending? Are they at risk if they file for a U visa? So although filing the application does not protect them at all, it's oftentimes better than remaining here without any options. And it's really up to the client to make that decision. The executive order that was enacted in 2017 was specifically written to enhance public safety in the interior of the United States. And any person who is here without status is obviously at risk. So filing a U visa application, although it does not provide lawful status, it might protect them in the future if that case is approved before ICE finds them. Deferred action, being placed on the wait list, may offer some protection. And then, of course, being granted a U visa does provide lawful status. So once they're granted the U visa, they're here with lawful status. And then there's the NTA memo that I mentioned. We also, as we're meeting with clients and providing consultation appointments, will explain the Know Your Rights presentations to them so that they understand their rights if they are ever confronted by ICE at home or in the workplace or on the street. Any questions about that? Yes? Mm-hmm. Yeah, so the question was the I-192 waiver, that's the waiver that you would submit for any inadmissibility grounds. Is that also eligible, or does that also cover unlawful presence? So if somebody entered the country legally with a visa, say a visitor visa or student visa, and then they overstay that visa, they're accruing what's called unlawful presence, okay? So immigration says that you begin to accrue that unlawful presence, but it's actually not triggered. The inadmissibility ground is not triggered until you depart the United States. So if somebody entered the U.S. on a lawful visa and overstayed that visa and applied for a U visa, they would not need a waiver unless there's some other inadmissibility ground. But if they've never had any crimes, never made any false claims to citizenship or smuggled their children, their only thing is that they overstayed their visa, they actually aren't triggering that inadmissibility ground of unlawful presence until they depart the United States. So we would encourage them to stay here until their U visa is adjudicated and then they're in lawful status. If they do depart, then they would need an unlawful presence waiver. Mm-hmm. Yes. Correct. So the I-601 form is not used for U visa applications because that is for immigrant visas or green cards. This is a non-immigrant visa, right? So this is a non-immigrant visa, which means it needs a non-immigrant waiver, which is the I-192 waiver. So for the U visa context, you don't have to worry about the I-601. Just pretend you never heard that. You're going to be focusing on the I-192 waiver, which is the waiver that we talked about. Yes?
Also, just generally, of the 10,000 that they get a year, like the applications that, I guess, many young perspective on the one you submit, what's the approval rate here for the well-supported application? Is it something that, like, once you have everything in place, it's pretty good? Or
Yeah.
is it, like, how much is this?
Yeah, so the question is, what's the approval rate or percentage? And obviously I can't speak to everybody, but, and the Vermont Service Center actually does issue the numbers. So that information is available. I don't know it off the top of my head, but in our office, it's close to 100% approval rating because we vet the cases so carefully up front. Now, I will say though, years ago, the Vermont Service Center was much more, just not so strict, right, with U visa cases. They've gotten stricter over the years. And so what may have been approved years ago might not be approved now or in the future. So because these cases are taking so long to be adjudicated, we don't have as much anecdotal information as I would like. But we recently did see a case where the client applied for a U visa based on felonious assault, and the crime occurred in the public way, which under Illinois law, there's an argument that can be made that then it rises to the level of a felony. There was no weapon used in that crime in this instance, and the abuse or the mental and emotional harm, physical or mental harm that was suffered was very minimal in this case. That case was just denied. Okay, so that's a case that years ago probably would have been approved, but we suspected that we're going to start seeing more pushback on borderline cases that we would call borderline. And so what we do is we look at them, at the full circumstance, and if we don't think that the client has a legal argument, we're not going to go forward. If we think that there's a legal argument, but it might risk denial, we'll explain that to the client and explain that, look, this could be a long road ahead because it might require litigation in the future. So generally speaking, though, this is a very good area of immigration law, and in that there's a lot of approvals. So that's nice because it's not like that in all areas. Okay, so what time is it? It is 1:06. So I'm going to skip the case example because Sylvia has some later that we can go over if we have time, but I want to make sure you guys get your 10-minute break. So why don't we take a 10-minute break and come back at 1:15? Take a 9-minute break. Questions? No? Okay. Thank you, guys.
Okay, so hopefully everyone is well rested in their 9 minutes. I'm going to move into talking about the actual details of preparing a U visa case. So things like getting started, client meetings, and then case evidence. What are the things that are required for a principal applicant versus a derivative applicant? So it's text heavy and there's a lot of information here. I'll sort of skip around a little bit, but really this section and the subsequent sections are meant as a reference. So feel free to use the PowerPoint and a lot of these examples, especially the examples of documentation you can gather in your future casework. So I'll try and make it interesting, but it is a lot of information, and so I'll skip around as needed. So getting started, sort of tying back to working with victims of domestic violence or working with individuals who have survived serious trauma, it's very important to build a relationship of trust. Some ideas for that can be creating a physical and emotional space where your client feels safe. So certainly meeting in a private room, avoiding legalese. So this is a lot of information to take in for all of us, probably. It's even more for the client to take in. So speaking to them simply on a one-to-one sort of person level rather than explaining the case and the situation using legalese. And then stressing confidentiality. A lot of our clients do have anxieties about what Tricia was mentioning, their abuser finding out about the case, or their family, or anyone finding out that they're undocumented if they are undocumented. So sort of stressing that this is a safe and confidential space, and creating that space for them. We also recommend explaining your relationship with NIJC, although we do always explain what our role is when we initially screen the client, and we explain this is a pro bono project, or case will be passed along to a pro bono attorney. It's helpful to reiterate that because we are throwing a lot of information at the client right at the start. Most firms have their own release of information and retainer agreement that they like to sign. So depending on what you do internally, that might be a good idea. And then setting up a communication plan can be critical, especially for individuals that are still either in abusive situations or are not in a secure location. Some clients are living in domestic violence shelters. So doing a safety check and asking, what is your preferred method of communication? We internally always flag whether an address is a safe address. But a client may move around, or circumstances may change. Maybe their abuser finds them and starts stealing their mail, or maybe their phone number stops being safe, or their email stops being safe. So checking in with them and asking, what's the best way to communicate with you? Do you feel comfortable with me leaving you voicemail messages? Do you have a preferred address, or has that address changed? Because as you work with the client, things may change. So just making sure you do that safety check. And then, of course, finding an interpreter if necessary. Explaining the application process can be critical, especially in building the relationship of trust so that the client sort of remembers and solidifies in their mind, how long is this going to take? How long does it take for me to get a U visa? What are the different fees or waivers? What additional documents do I need to bring you? Again, we at the front end get the certification for you, and we try and copy as many documents as possible, but we may also let the client know, please gather documents XYZ for your volunteer attorney. Or as you work in the case, you may find out that there are additional pieces of evidence that will be useful to you. So letting the client know that. And reviewing a list of documents. We have a sample list of documents in our manual appendices on our website, and we have a number of very helpful resources on our website that are readily available to you. And then being prepared for questions beyond the scope of your representation. So right now it's tax season-ish, right? Hopefully we've all filed our taxes, but we have a lot of clients asking, I'm not sure what I'm supposed to do with XYZ for my taxes. We have a ton of referrals. We often refer people to the Center for Economic Progress. It's an organization that works with low-income individuals to assist them in tax filing. So if a client asks you, I need this, or this, certainly we never expect you to handle that situation, but you can reach out to us and we can provide you a number of referrals for things that commonly come up and that we've seen come up as we work on cases. Client meetings. So Tricia already brought this up, but I'll reiterate. It's highlighted in bold. Gather that U visa certification form, the original, at your first meeting. At your initial meeting, it's recommended that you learn your client's story, make copies of whatever additional documents they brought you, gather information, give them a list of additional documents they need, and schedule your next meeting. Things like the affidavit, you'll have to gauge the comfort level of your client and your own comfort level. Is this a person who suffered severe trauma, and maybe you need to build more trust before you start to get into the affidavit and asking them specifically about the details of the abuse they suffered or about what's going on in their life. So I'd recommend that you wait until subsequent meetings to begin working on the affidavit and to begin gathering that story. That also depends on the client. Maybe it's someone who was a victim of felonious assault several years ago and they've moved through it, and maybe they are ready to work on the affidavit at that first meeting. So just sort of being aware, not every client may be ready to provide you with all of that information right away. And when we do our legal screenings, we also give you the case notes from our legal screening, so you'll have a basic understanding of who is this person, who are their family members, more or less what happened, but those are our internal case notes. So, you definitely want to confirm all of that information, and you want to have a look at it before you meet with your client. So in subsequent meetings, we recommend working on the affidavit, copying additional documents, and finalizing forms. So what is the affidavit? What does it look like? And what should it look like? Well, it should be in the applicant's own words and signed. So in the applicant's own words can mean a lot of things. It can mean that the person was able to write something lengthy, extensive in their native language. You had a translator translate it, certify that translation, and it was the perfect affidavit. Everything was covered in what the client initially wrote. That almost never happens. Most of the time, there are things that you need to add to that affidavit, right? Especially when we're talking about the cycle of abuse and abuse tactics. Most of the time, clients are not aware of what information is going to be important, especially in terms of positive discretion for their inadmissibility waiver, what things they should be talking about. So sometimes clients will draft something that you can then work with them on. My preference is to sit down with the client and draft something together. And the client's original signature is required on that form. And if you're working with an interpreter, the interpreter must also sign, sorry, I said form, but I meant the affidavit, right? So the last page of the affidavit should be a signature page indicating that these are the client's own words and that whoever was working with you to interpret provided a truthful and accurate interpretation. So what must the affidavit address? Some of the key things are, of course, basic biographic information, entry into the United States, exits, if any, substantial mental or physical abuse. And so that's most applicable to the principal, typically, because it's one of the required pieces of proof for the U visa. Knowledge and information about the crime, cooperation, how was that person helpful to law enforcement in the investigation or prosecution of the crime, explanation of the circumstances giving rise to any inadmissibilities, right? So, anything like criminal history, entries and exits, past deportations should be explained. For example, if a client has an arrest for theft, you may want to ask more questions about that. What happened? Was it tied to the abuse? There are situations in which a victim of domestic violence, for example, I had a case where a client was left at home with her young child, and of course, because of economic abuse, didn't have access to money, didn't have access to really anything, and there was no food in the home. So she went out and she took something from a store, she was arrested. It was directly tied to the abuse. It was something that came out of the desperation of that situation. You want to explain arrests, why they happened, especially if there are any mitigating circumstances that are tied directly to the abuse that the person was suffering. And then, of course, reasons why it would be in the national or public interest to grant that waiver of inadmissibility, right? U.S. citizen children, significant ties to the U.S., and things that Tricia already mentioned, like lack of access to the criminal justice system in home country. So all of those things can be brought up. Other things you will want to provide are identity documents like birth certificates, marriage certificates, and this goes for both principal applicants and derivative applicants. Primarily for the principal applicant, you'll have to prove U visa eligibility. So victimization, that substantial harm that I've already mentioned. And the main way that you'll be proving that is with the applicant's affidavit and then any additional supporting documents that the client has. So some clients will have a lot of these things, and some clients will have almost none of them. And that doesn't necessarily speak to the strength of the case. It may just speak to what documents was the client able to gather and what situation they're in, right? So police reports are probably the most common secondary document that we get. Some people might have medical reports or medical records, especially if the harm was so severe that they were then hospitalized. Intake records from a domestic violence shelter can also be helpful. And then some clients, mainly what they'll have is affidavits from secondary sources. So family members, friends that saw what they were going through in the relationship who are willing to write a letter of support and then sign that letter of support explaining what the principal applicant went through. For the derivative applicant, some of the main documentation that you'll need is proof of qualifying relationship, Oftentimes that's things like a birth certificate or a marriage certificate, current passport, and then expired passports, especially if the person, for example, entered lawfully. So you want to be able to provide proof of lawful admission to the United States. And then that person must either be admissible or file the waiver of inadmissibility. So the principal applicant will need their own set of forms, and the derivative applicant will also need their own set of forms. So a principal may need a waiver of inadmissibility, and also a derivative may need their own waiver of inadmissibility. For the waiver of inadmissibility, the affidavit should, again, address both for the principal, who has their own affidavit, and for the derivative, who has their own affidavit, what are those inadmissibility grounds, why did they happen, and what's the positive discretion for that waiver to be granted. So things like taxes can be very helpful, right? This person is complying with the law, they're filing their taxes, family ties, school records, medical records, et cetera, and of course, letters of support. So any questions before I move on to filing procedures? Those are just sort of the general examples. Again, not every client will have every piece of evidence, but you can certainly use this to think about what kinds of things additionally can I ask for from my client. In terms of filing procedures, what are the actual things you will want to gather? What will you want to include in an application packet? There's the way I think about it and the way we recommend you prepare this is sort of separate application packet for the principal applicant with its own cover letter and required forms and supporting documents, and separate application packet for each derivative applicant because they will also need their own cover letter, set of forms, and supporting documents. So that's helpful also for USCIS so that they have that clearly marked, right? Who is the principal? Who is the derivative? What are we using as proof for each of these applications? So since many of you have worked on U-Visas before, this is sort of the general list of forms. I think I saw a hand up. Yeah.
So in situations where client had to leave or flee or access documents were kept from by the requester, do you, when sort of presenting the application packets and you then talk sort of, I presume then you have to talk sort of at length about the affidavit and the cover letter as to why certain documents are missing. If that is the case, are there often regarding those documents, or is there specific understanding that, you know what, we get it,
Yeah, it really, so my answer sort of depends on what documentation is missing. And so there are certain documents that are required, right? You have to have a passport in order to apply for a U-Visa. In certain situations, it becomes impossible for individuals, maybe children, who are children both of the victim and the abuser, if they need both parents' permission to get a passport, that becomes impossible. So it's possible to waive the passport requirement in the inadmissibility waiver. So certain things, certain initial evidence is required. And when we screen a case, we check for that initial evidence, especially because there is an RFE NOID memo. And so if certain initial evidence is not submitted, immigration can reject that application. The U-Visa certification may expire. So there are certain things that it's very important to submit or request a waiver for. Other types of documentation, we again remind immigration of the any credible evidence standard, right? So maybe the client doesn't have a lot of proof of abuse, but they have a lot of letters. Immigration may RFE, right, send a request for evidence saying, you know, your affidavit and these letters and this, you know, this order of protection isn't enough. We will politely or maybe aggressively remind them that the standard is any credible evidence and the person was fleeing violence and they don't have a ton of information to provide. So it sort of depends on what information is missing. If it's something like a police report, you can FOIA for police records and police reports. So we try and mediate and get as many documents as possible. But again, it sort of depends. You want to make sure that you're submitting all of the basic documentation that's required in order for the case not to be rejected. So that's a great question. Sure. So back to cover letter and forms. Of course, you'll want a detailed and argumentative cover letter, your G28 representation form. The I918 is the U visa application form. You must submit the original I918 Supplement B, which is the certification form signed by law enforcement or whoever was prosecuting or investigating the crime. Form I-765, that's the employment authorization document. You'll notice that there's a category listed here. So once someone is placed on the deferred action waitlist, they become eligible for a category C14. That means deferred action based employment authorization document. We recommend submitting that with the initial application if the client is eligible for a fee waiver, because that way immigration will adjudicate that once the client is placed on that wait list. If the client is not eligible for a fee waiver, you can also wait to submit that I-765 because it does cost $410. And we can't guarantee what the status of that wait list will be several years onward in the future. That's just a small caveat. And I'll talk a little bit more about different types of employment authorization later on. Form I-192 is the waiver of inadmissibility. And then, of course, there are fees. So Form I-192 costs $930 right now, and Form I-765 costs $410. Most of our clients will qualify for Form I-912, the fee waiver request. Supporting documentation, you'll want to submit that after the forms. So it'll go cover letter, forms, documentation, and that'll be things like the affidavit, all of the evidence, and the sort of required documents to prove all of the elements of the crime and admissibility or documents for the inadmissibility waiver. Same thing goes for derivative applicants. The central differences here are you'll want to submit 2 G28s, one for the petitioner, and the reason for that is the I-918A, even though it's being filed on behalf of the derivative, it's being filed by the principal applicant on behalf of the derivative. And so you'll want a G28 both for the principal applicant and for the derivative in that filing. So you'll want 2 G28s with the derivative application. Form I-918 Supplement A is the U visa derivative application, and then you'll see 2 different types of employment authorization applications here. Form I-765 for category A20 and for category C14. So C14 is for that deferred action waitlist. That's the step 1 before approval. And then unlike principal applicants who automatically receive an A19 employment authorization document once their U visa is approved, there is no automatic EAD or automatic employment authorization document issued to derivatives. So you'll have to submit a second Form I-765 category A20. There's a lot of different categories. There is a slide that sort of lays this out more clearly for you, but that's sort of the difference in employment authorization between principals and derivatives. Of course, if the derivative also needs their own waiver, you'll submit Form I-192, and then the derivative will also need their own fee waiver form if they qualify. So that's sort of the nitty-gritty of the pieces that you'll want to file with each type of case. Supporting documents. Oh. Mm-hmm. There is.
Wouldn't the fee waiver, so the I-192, separate?
No, you can list both forms on the same fee waiver. So it's just a matter of making sure that you request a fee waiver for the I-765, for the I-192. If you're submitting 2 I-765s, you request fee waiver, same form, but please waive 2 times the I-765, 1 time the I-192. Mm-hmm. 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 Yeah, so usually the I-192, the I-765. So yes. So I'm sort of presenting this to you as 2 separate application packets because what USCIS typically does is they'll separate the petitioner and the derivative, which is why we want to make sure that each applicant has their complete set of forms, because most likely they'll tear these apart and they may adjudicate one at one time, one at another time. Does that answer your question? Yes? Okay.
So I just want to add, thank you.
Sure.
You guys explained this all really well, but as you can see, like, immigration is very particular about all this stuff, which is why we'll do a review of the filing before you file it, just because sometimes it's helpful to have another set of eyes. At least four.
Yeah.
It's a lot.
Yeah, we absolutely review. We're happy to provide review of all application packets before you actually submit to USCIS, because we realize it's a lot. It's a lot of different pieces, and we have our own best practices. Maybe you filed U visas with other organizations, and so these are our recommendations for how to file. Supporting documents as well. All right, so additional information, tips and tricks, things that are important to remember. I'll sort of break down the EADs, the employment authorization documents, a little bit more, talk a little bit more about the fee waiver and filing fees, tips, and then where to file. So again, the employment authorization can feel a little bit convoluted, but you can frame it in your mind in this way. There are 3 types of employment authorization that apply to the U visa. Category A19 is for the U visa principal applicant once the U visa is approved. Category A20 is for the U visa derivative applicant once the U visa is approved. And category C14 is for that deferred action waitlist. And so the way to break this down is once immigration begins to look at the application, they may say, okay, this is a case that's approvable, and we would issue you a U visa. We don't have one. We've reached the 10,000 annual cap, and there's not a U visa for you, so we'll place you on the wait list. You can now have employment authorization. You can work lawfully. Using that employment authorization, you can get a valid Social Security number, and so you have category C14, deferred action employment authorization. The other 2 are for once your U visa is finally approved, and I would say that's the main difference. Any questions on the EAD? Okay. Yes.
As soon as you submit it, do you get on the wait list? Or
No.
time?
So they're looking at cases filed in 2015 for the employment.
Okay.
Yeah.
Once they actually review it, is there any other time to wait list?
Yes.
Okay.
Yeah. So the first thing, and I'll talk about this a little bit later, but the first thing that they do is they'll issue you a receipt, and then the case will just sit there until they have a chance to look at it. And right now, that is taking several years. Okay, so this is just a breakdown of the forms and fees. Again, Form I918 and I918A, which are the actual U visa forms for principals and derivatives, don't cost anything. So they will be feed in. Immigration will accept them. But Form I-192 and I-765 either require a fee or a fee waiver form. And so if, for example, your fee waiver is rejected, immigration will accept forms I-918 and I-918A because they don't carry a fee, but they may reject form I-192 and form I-765, and then you'll have to refile that either with fees or a stronger fee waiver application. So fee waivers. The Vermont Service Center used to be very, very generous with fee waivers. That is unfortunately no longer the case. And so it's extremely important to prepare a strong fee waiver. There are 3 ways to qualify for a fee waiver, and they can sort of be mix and match together. If the applicant is receiving a means-tested benefit, so right now, U visa applicants are actually eligible to receive public benefits. If they themselves are receiving the public benefit or the head of household is receiving a public benefit, you can provide proof of that public benefit and proof that they qualify for the fee waiver. The most common way to qualify is having a household income that is 150% or below the federal poverty guidelines. So it's important to provide substantial proof like paycheck stubs, taxes, an employment letter, really as much as the applicant can provide to prove to immigration that they actually are 150% or below that guideline. And then financial hardship. So sometimes clients are not working, or especially for victims of domestic violence that have recently escaped their abuser, maybe they're in a shelter, and maybe the shelter can provide a letter saying this person has no income, they're currently living and residing in this shelter. They don't have any proof of of not having an income or of making 150% or below the federal poverty guideline, but they have this letter from an organization that says they're not making any money, they're actually in this shelter right now, and we're providing them housing. So you can certainly, for example, mark household income is below and hardship. You can make the client qualify via both of those options, but you'll have to provide as much documentation as possible, otherwise that fee waiver will be rejected. Any questions on the fee waiver? Okay. Filing tips. Just a reminder, all foreign language documents must be accompanied by a certified translation. That doesn't mean you have to, go pay for an official translation. All it means is that the translation has to be signed by the translator, and that person certifies that they're competent in English and that foreign language to do that translation. So we have sample or template translations that you can use. We have a template birth certificate translation form. We have a template marriage and divorce decree translation form that's available for you on our website, and whatever translator you're using can certainly sign those things, but all foreign language documents will have to be accompanied by a translation. For USCIS forms, USCIS can change their form, often without much warning. And so before you file, make sure you're using the most recent and current version of the form. You can check directly on the USCIS website. And the same goes for fees. I think the fees went up not this December, but last December. And they can change the fees as they want to. So just making sure that all of the things are still up to date and current. Logistics. For the actual physical application packet, we recommend you 2-hole punch it at the top and bind it with metal fasteners. Do not use any kind of spiral binding. Do not use any kind of tabs that stick out. So very much unlike any kind of court filing. You can use what do you call those? Like stickers, exhibit stickers. Because what I've heard is that USCIS inputs all of their documents into their online system, and so if there are any tabs or any spiral binding or anything on that, they hate it. So don't do that. Don't make them angry. So for derivative and principal application packets, I've already mentioned, we recommend you create separate application packets that have all the forms and all the required documents for principals and for derivatives, because most often USCIS will separate those, tear them apart, and you want to make sure that they don't think anything is missing from either application packet. You can, though, place the application packets in the same mailing envelope, but we do recommend that you file either via FedEx or any other trackable delivery service so that you yourself have proof that the application arrived on time in case any kind of argument later needs to be made that you filed timely. Where to file? All of these applications go to the Vermont Service Center, and that's the address. And then what happens next? Well, the first thing you'll get are receipt notices for every form that you filed. Typically, this has been taking 4 to 8 weeks. We've seen this take longer, maybe 9 weeks or more. But you should get a receipt notice for every single form that you filed. So the I918, the I765, the I192, every form you filed for this, for each applicant, immigration should provide you with a receipt. If they don't, let us know and we'll talk you through the steps of requesting those receipt notices. The next thing that'll most likely happen is your client will likely be scheduled for a biometrics or fingerprinting appointment. This isn't like a formal interview. It's really just the client going in, their fingerprints get taken, and those then get sent off to their application for review later once their case is being adjudicated. For derivatives abroad, they will not receive a biometrics per se because they're not going to be scheduled for biometrics here in the US. They'll receive something like a request for evidence for biometrics abroad. And with your help, you'll have to schedule an appointment for them abroad at the nearest consulate or embassy in their home country for them to actually take their fingerprints abroad. So that should arrive maybe a week or two or a few weeks within the receipt notices as well. And the processing times are published for the Vermont Service Center are published on the USCIS website, and those sort of change quite frequently. So right now, they're published there, but they may not necessarily be the most accurate. USCIS can RFE, they can issue a request for evidence, and if they do, make sure you let us know so that we can have that information in our records. And if you have questions, certainly at any time during the time that the case is pending, we're more than happy to give you resources and to help you answer any RFEs that may come up. So we've already talked extensively about the U-Visa deferred action waitlist. Because we don't want the processing times to be a deterrent for people to take on cases, at the waitlist stage, we are willing to take the cases back in-house. So if your client's case has been placed on the deferred action waitlist but not yet approved, if you want us to take the case back in-house, we're happy to do that, and you can reach out to us if that's something that you want to do. U-Visa approval. So in the same way that you'll get receipt notices for every form you filed, you should also get approval notices for every form you filed. So for the I918, the I-765, and the I-192. You may receive all the notices and the employment authorization card all at once. They may arrive several weeks apart, so definitely don't worry if you don't get everything at the same time. Sometimes they arrive, and actually quite frequently they arrive separately. If there are travel issues, so for example, if there are derivatives outside the United States, you will close out the matter and the clients can come back to the National Immigrant Justice Center for help with consular processing. So let's say they have a child that's abroad, they now have an approved U-Visa, we will help them consular process into the United States at NIJC. And then after 3 years in U-Visa status, the client becomes eligible for adjustment of status or the green card, which is a huge benefit. If the client contacts you after those 3 years, you can just refer them back to NIJC. We also do adjustment of status applications. The important thing to remember, and what we include in our closing letter to the client, is that they must apply for adjustment before their U-Visa expires, or they may lose the opportunity to do so, right? So the U-Visa is typically valid for 4 years. Within 3 years, they're eligible to apply. So we try and remind clients of that. We tell them in our closing letter, but if this ever comes up, you can also let them know. Because the cases are pending for so long, it's extremely important to keep in touch with your client. For example, clients may move around, and if they do move, it's required that you notify immigration of their change of address. There are special instructions on the USCIS website, and we're also happy to walk you through changing that address for the clients, and they should also keep you informed, right? So in the same way that we talked about the safety check, they should keep you informed of their current address, their current phone number, any marriages or plans to marry that can affect their U-Visa application, any arrests, anything that could be relevant to their case, they should keep you informed of. And so that's something that's helpful to remind clients after you file, or even in letters once you send them their receipt notices. One thing that is important to note is, because the Vermont Service Center works with vulnerable populations, if a client has a G28 on file, so if they are being represented, immigration and the Vermont Service Center will never send any documents to the client. No receipt notices, no biometrics notices, everything will go to their attorney of record. And so it's very important for you to notify the client of any updates in their case, especially to notify them that they have to go to their biometrics appointment, and you must provide them with that appointment notice so that they can go. So that's something that I like to note, because everything goes to you and nothing goes to the client. So I don't think we have time for case examples. Maybe?
Why don't we skip to that end part, and then if we have time afterwards.
Okay. Sounds good. I also want to make sure we have time for questions. So these are some of the legal resources that we use throughout the presentation. There are a lot of other resources for inquiries to the Vermont Service Center or for the Domestic Violence Helpline. And then here is our contact information. The next steps, you'll start to receive the NIJC email newsletter, which will include our case list. Our case list is also available online, or you can contact me directly whenever you're ready to take on a case. My contact information is here. And Tricia provides supervisory case review. So once you've put together an application packet, we'll give you a comprehensive set of edits or suggestions or comments, but these are the general next steps. So we just want to say thank you so much for being here with us. I know it's a long presentation, but hopefully you feel prepared to work on a U-Visa case, and we'll be there with you every step of the way. We're always available for questions. You can call us, you can email us, and we're happy to be in touch.
Anybody have questions?
Yeah. Yeah.
Right. So typically now we would encourage somebody to go forward with a T visa. I think, so I'm definitely not a T visa expert, but with my limited experience with T visas, I think one of the requirements for a T visa is proving that you're in the United States on account of the trafficking. And if that is hard to prove, then a U visa might be a better route. But most T visa or trafficking victims, we would recommend that they do the T visa, if not both, right? Because they're going to get status so much faster, and that cap has never been met. So, but that's a great question.
Yeah, definitely.
Yeah.
And we.
Go
ahead.
Go ahead.
No, go ahead.
Well, strategically, sometimes clients qualify for more than one form of relief, and we'll talk them through what makes the most sense. And sometimes they'll apply for both, right? Like, so we have clients who are maybe they're applying for asylum through our pro bono project, and then they discover that they're also eligible for a U visa, and so we'll screen them, and if so, maybe that pro bono attorney will help them file the U visa. If a client is already with you and then discovers eligible for some other form of relief, that doesn't mean you're stuck doing it, but let us know. We'll screen them for that other form of relief, and if so, figure out what makes the most sense.
Yep.
What were you going to say?
I don't know. No, that's okay. That's okay. Yeah, and we do have a trafficking project at NIJC as well, and so we definitely work together to determine what's the best form of relief, and our multiple forms of relief, something that is viable for the client. Yes.
Yeah, I have
Mm-hmm.
and I think she also might have a
Mm.
and I'm concerned about the because not any she's very reluctant to. So the case we did file certification from the state's attorney.
Mm-hmm. Yeah. Sure. Yeah. Mm-hmm. Yeah.
So I'm concerned just about
Yeah. I mean, so that's, we're happy to screen this person for a U visa if you'd like to refer them to us. I mean, I think those are things we weigh with every case that we screen, right? What is the documentation that we're going to be able to gather? But also we try and give agency to the client. And so we certainly can't force anyone to report, and we can't force anyone to continue cooperation. What we can do is tell them these are the requirements, this is what the process will look like, and give them that information and empower them to make those decisions themselves. I think counseling can be huge. We've had several clients sort of turn back around and decide to apply for a U visa and decide to continue cooperating after receiving counseling. We also can't force anyone to go to counseling. And so, from our perspective, we would screen that on the front end and see if the client is ready to move forward on that form of relief. They may not be, and they may come back to us in 3 or 4 years when they are ready, or if a new instance has occurred. But I think all we can do is offer those individuals the resources, and when they're ready to take them. Yeah, I know it's tough. It's a tough situation. We see cases like that, and we try and give people all the resources that they can get. And sometimes they do come back when they're ready to apply. Yeah.
I guess, is there any movement at all about like certain agencies? It doesn't sound like it's Chicago, but other places not signing certifications. It just seems like it's just like totally discretionary that they don't have to do this. I mean, I think it's crazy that this law would be built up in this way, but leaving this huge platform.
So there has been huge movement, and Tricia, I'll let you talk about it because you were instrumental in this, but the Voices Act did pass in Illinois.
Yeah, so here in Illinois, we have the Voices Act, which actually says that if somebody was a victim of a crime, law enforcement has to sign the certification, which is great. It just went into effect January 1, so it's new. There's a similar law in California, but you're right, there's these huge holes where, depending on where you were a victim of a crime, can really determine if you can get a certification. Can't get a certification, you can't apply, which seems really unfair.
Yeah.
So we're working on it, right? There's actually a bill proposed in Senate, I think, U.S. Senate, to remove the requirement of the certification, but I don't expect that to go anywhere, right? So maybe someday when we have a gentler administration, but for now, we do what we can locally. And the other part of that is we do a lot of outreach to law enforcement. So, I think that in welcoming cities and immigrant-friendly areas, maybe it's a little bit easier. But we've had some pushback in the collar counties, which is getting a little bit better now with the Voices Act. They, have to sign it. And so they're asking us, okay, what is this about, right? So we go and we do presentations and explain to them how the visa can actually be really helpful to law enforcement too. And so we do in our office a lot of what we call youth certification advocacy, where a client will come in, was a victim of a crime in such and such place. It might be in the middle of Oklahoma or something, where we don't know if that law enforcement agency knows anything about e-visas. And so we will reach out and then advocate for the clients to get the certification signed and explain to the law enforcement agency why it's in their best interest to do this. So we do what we can.
Yeah. And I think there has been improvement. We've definitely seen huge improvement. And agencies that previously weren't designating certifiers and weren't signing are now signing. So we're moving forward despite all the obstacles.
Well, thank you guys. We don't want to keep you past. It's 2:00 on the dot. Enjoy the rest of your afternoon. If you have further questions, Sylvia and I can stick around and answer those.
And a couple important things: make sure you sign in, make sure you do the evaluation, and I will hold your CLE certificate hostage and trade you for the evaluation.
Thank you.